Thank you all so much for joining us today. We'll go ahead and get things started just to be cognizant of everybody's time. We're excited to have the opportunity to connect with you all. If you have any questions throughout the session, please use the chat function at the bottom of your screen, and Professor Coordes will try and answer as many questions as possible at the end of her presentation. We are recording this meeting and we'll send out the recording as well as the PowerPoint presentation following the session. So with that, I'm excited to introduce Professor Laura Coordes. Professor Coordes' research focuses on bankruptcy and financial distress and includes commercial law, large corporate reorganizations, and local government finance and policy. She teaches Chapter 11 bankruptcy, advanced bankruptcy, secured transactions, and contracts. She is an active member of the American Bankruptcy Institute and serves as a volunteer editor for the ABI's VOLO project, which summarizes and disseminates bankruptcy-related circuit court opinions. Professor Coordes has served as a peer reviewer for the American Bankruptcy Law Journal and is an honorary master of the Arizona Bankruptcy American Inn of Court. She also serves on the Education Committee for the 2021 National Conference of Bankruptcy Judges annual meeting and the Education Committee for Credit Abuse Resistance Education. Professor Coordes, I will turn it over to you.
Thank you so much, Kelly. And thanks for the opportunity to be here and to speak with all of you today from the comfort of my home. This is like the best ever because I don't have to travel to give a presentation. A couple of things before I kind of get into the presentation. I realized, first of all, as I was thinking about this earlier today, that I probably should have subtitled this "More Questions Than Answers," because like pretty much everything else that COVID-19 touches, there's a lot of uncertainty. It's very difficult to sit here and try and predict the future, even in good economic times or good circumstances. And then you add COVID to the mix and it just, gets incredibly difficult, right? There's constant change. So the things that I'm saying today, I'm, making sort of educated predictions and thoughts, but I imagine that they could change tomorrow with the rate that things have been going. And so there's lots of potential for volatility here. That being said, the one thing that I do think we can say with somewhat certainty is that COVID-19 is going to impact the number and the type of bankruptcy cases that we'll be seeing. In particular, I think that we're going to be seeing a lot more bankruptcy cases than we've seen in the past couple of years when the economy was doing pretty well. And so for this reason, one of the biggest things I think we can do to get ready for all of this, whether it's a surge or a wave or even just a slow, steady rise of bankruptcy filings, is we can boost the capacity of our bankruptcy courts. So we can get Congress, hopefully, to appoint additional bankruptcy judges, even if on a temporary basis. And we can ask them to increase the budgets of our bankruptcy courts so that they can boost their own capacity, so that they can recall retired judges or add new clerks. And so, I think no one obviously, again, can say for certain how much bankruptcy filings are going to increase or how quickly or slowly that will happen. Although I'll make some predictions as we'll see. I do think that there's almost certainly going to be an increase of filings to the extent where I think the existing bankruptcy court system might become overwhelmed. So I'm just going to say that right off the bat, and I'll return to this theme several times during my presentation. So again, in thinking about how to kind of structure this presentation, I realized it's going to take so much more time than we have to fully unpack the impact of COVID-19 on bankruptcy and the bankruptcy system. And so I'm going to, for the sake of time, assume that the majority of you who have signed up for a presentation on bankruptcy and COVID-19 have some knowledge of the bankruptcy system or bankruptcy basics, although I'm happy during the Q&A to address questions about the bankruptcy process. For now, though, I thought I'd focus on 4 kind of high-level areas that I think deserve particular attention in light of, COVID-19's impact on the bankruptcy system. And so those 4 areas are outlined below: large business, small business, which I think deserve separate considerations for reasons I'll go into, consumers, and last but not least, municipalities. So starting right off the bat with large businesses, I did say I wouldn't focus too much on bankruptcy basics, but I think it's worth taking a pause when we think about, will bankruptcy help large businesses cope with the economic fallout from COVID? I think it's worth taking some time and thinking about what bankruptcy's benefits are, particularly for business. And so I put up a non-exclusive, non-exhaustive list of benefits that I think bankruptcy can do or bring for a business. So obviously, breathing space is a great benefit. When you file for bankruptcy, when a company files for bankruptcy, they get an automatic stay. It automatically stays all litigation, all collection efforts against the company. So the company gets breathing space to assess its debts, to maybe start negotiating with creditors. It gets time to address operational challenges that it might be having. It basically gets a reprieve from creditors breathing down its proverbial neck. And that's very beneficial when things are moving at a fast pace and maybe getting out of control, or you need time to just sort of assess how your business is going to work in light of a changing economy, a changing world. Bankruptcy also gives you the ability to break contracts, to breach them. Of course, you can breach contracts outside of bankruptcy as well, but the damage claim that you pay in bankruptcy is, generally speaking, substantially smaller. You can pay your damage claim cents on the dollar to the non-breaching party. So it's cheaper to break contracts in bankruptcy than outside of it. And so this is a good place, bankruptcy is a good place if you entered a contract and you're not quite sure how, you no longer think it's beneficial for you and you want to get rid of it. Bankruptcy can be a good place to do that. I think pretty obviously bankruptcy, or Chapter 11 bankruptcy in particular, which many large businesses will seek to use, is beneficial for debt restructuring, right? And the way we typically restructure debts, oftentimes shareholders of a company are wiped out, old debt is renegotiated or can be converted into new equity. But obviously bankruptcy is a great place to come up with a plan for how you're going to pay and restructure your debts. And then all of these factors together kind of work to give the company a fresh start. So hopefully at the end of a Chapter 11 bankruptcy case, the company will emerge from bankruptcy with sort of, a plan in place to pay its debts and, better, more sort of solid on the operational front even as well. So I think the next question that we should ask is, does bankruptcy serve large businesses well in a crisis? And here I think the answer is yes. If we look back to recent history, to the Great Recession, 2008 or so, obviously many businesses failed during that time, but many were also saved. General Motors are two notable examples that come to mind. There were obviously those are not perfect bankruptcies by any means, but they're still around today. And so I think Chapter 11, which again is the chapter of the bankruptcy code that most large businesses would probably seek to use, it's not perfect. It's got some problems, but all in all, it does a good job of doing functionally what it was designed to do, which is it's designed to help, generally speaking, these larger businesses get that fresh start, get that breathing space, and so on. So I tend to agree with the people that say bankruptcy is going to be a big player for large businesses. Bankruptcy should be what large businesses use, particularly if the federal government steps in, as it seems like it's been willing to do through the CARES Act, maybe through other legislation, to provide liquidity to these businesses, to prevent or mitigate job losses, to stabilize other aspects of the financial sector, right, to make sure that liquidity can continue to be provided for these businesses. I think Chapter 11, working in conjunction with sort of this federal government relief, has great potential to be effective for big business. And I do think that big businesses will need bankruptcy now more than ever. Obviously, the COVID-19 crisis has caused substantial economic fallout and substantial disruption for businesses. But even before COVID, many businesses were getting, I guess what I'll call financially sloppy, in the sense that they were dramatically taking on more and more debt. So J.Crew and Neiman Marcus, both of which are in bankruptcy, are good examples of this. Companies that they call them, I think, zombie companies that like gorge on debt that they will never be able to repay. So even before COVID hit, I think the rating agencies were kind of eyeing some of this corporate debt and saying, is this really going to be able to be paid back? And, you know, maybe not, but this problem of sort of debt overhang, way too much debt, is one of the problems that bankruptcy was designed to solve. So I think it will work pretty well for these big businesses. Again, also in conjunction with the government, which has been pretty willing to help large businesses. There are downsides, obviously, to government funding. I'm not saying the government should step in and like bail out all these businesses, but I think if the government is willing to play a role here, that in conjunction with bankruptcy can be a pretty good tool to address the problems of large corporations. So I think this seems pretty promising. I mean, for our large businesses, bankruptcy seems like a pretty promising option. Again, not perfect, has downsides, but you know, bankruptcy is designed to be used more or less by these large businesses, and I think it will play a pretty critical role here. See if I can move on to small businesses. So small businesses are a little bit of a different animal. And for that reason, I think bankruptcy, I tend to agree with the people that say bankruptcy is probably not going to play as big of a role, or maybe it won't without some adjustments. So it was obvious even before COVID-19 hit that Chapter 11 was not working well for small businesses. It was very expensive for them. They often had poor outcomes. So a small business might go into Chapter 11 seeking to reorganize, and they'd end up having to liquidate, or you know, they just couldn't get the results they wanted. And then, you know, if you think about how I said a debt restructuring often goes, you know, owners are often the ones that are wiped out at the end of the day, right? Creditors take over. And so if you're an owner of a small business, you don't really want to use bankruptcy because there's a real risk that you could lose control of your business. And so, you know, to the extent that they had a choice, a lot of small business owners probably weren't jumping to file. And so it was so obvious that Chapter 11 wasn't working that Congress actually passed a law last summer, I think it was in August, called the Small Business Reorganization Act, which created a new subchapter 5 for small businesses specifically. And lucky us, subchapter 5 went into effect in February of this year. And subchapter 5, basically what it did is it was designed to address all those problems I just mentioned. It created a new process for small business bankruptcies. It was designed to be less expensive, designed to be faster, designed to be more in line with the needs of small businesses. So owners don't necessarily get wiped out under a subchapter 5 restructuring. And last I checked, which was last week, according to statistics from the Department of Justice, about 350 small businesses are currently using the process. I imagine that number is a little bit higher this week, but just to give you a sense of the usage. However, as I put on the slide, as great as subchapter 5 seemingly is, I mean, we haven't really tested it yet, I don't think it's a magic bullet. It's not going to solve all of the problems we have with small business bankruptcies. And I think this for a couple of reasons. One is that the law actually only applies to a small subset of debtors that we would consider to have small business problems. So I'm going to throw some numbers at you, and these numbers are going to sound huge, but trust me when I tell you they're not. So originally, subchapter 5 was only available to those with debt under $2.7 million. Now, temporarily, thank you, CARES Act, those with debt under $7.5 million are eligible. But all the research I've read suggests that this is still not enough. We need the debt limit to be higher, in other words, because we think that small businesses actually have larger amounts of debt than what I guess Congress thinks. And so it's not clear to me that that subchapter 5, even if it works beautifully, is only going to be available to a fraction of maybe the debtors that need it. One of the big problems is as well that subchapter 5 is it's so new, right? And we don't have a lot of precedent for applying and using subchapter 5. I think when Congress designed the Small Business Reorganization Act and thought about launching subchapter 5, maybe it thought, well, we'll test this out, test drive it during a time when the economy is doing fairly well, and then we'll, by the time we have another economic downturn, we'll have worked out a lot of the kinks. Well, obviously that didn't happen. It rolled out in February, and then the economy took an immediate downturn. And so I think subchapter 5 is going to be used a lot more, and it's pretty untested, and there are probably issues that will come up. I'm sure there are issues that are coming up that we just haven't thought of or resolved yet, because we were supposed to be test driving this essentially. And related to that, it's unclear whether we even have the capacity to administer a whole bunch of sub 5 cases. One of the things that's different about subchapter 5 is these cases get what's called a standing trustee. So a trustee to kind of help with certain aspects of plan payments and so on. But they need to have these standing trustees, and we have only just begun appointing standing trustees. So, and then just one more thing about sub 5, and then I'll shut up about it. But I think the other thing to remember, and this is true with regular Chapter 11 as well, is that bankruptcy doesn't really work without funding. So businesses will need access to funds, and I think right now there are still barriers to businesses in bankruptcy accessing those Paycheck Protection Program, those PPP funds that Congress has made available. And there's a lot of confusion, even if they want to access them, how they would do that, if they would be able to use them as grants or loans or things like that. And so I think a lot of that needs to be straightened out before we can say, okay, we should, let's let all these small businesses file for bankruptcy. And again, even if sub 5 does work amazingly well, and I'm totally wrong about everything that might go wrong, bankruptcy courts are then going to be overloaded with these sub 5 cases. And that goes back to my point about needing to boost capacity. So I do think that bankruptcy is going to be valuable for small businesses, thanks especially to subchapter 5 and the Small Business Reorganization Act. But again, there's just a lot more uncertainty here, and I think there's a greater chance, because most businesses that file for Chapter 11 are small businesses, there's a greater chance of sort of overwhelm on the bankruptcy courts in this capacity, and then they will not have the capacity really to deal with a new and untested law. So that's my take on small businesses. Thinking now about consumers. So if you look at the news, you will see lots of predictions about a coming wave of consumer bankruptcy filings. And I think I've read many different estimates as to when this wave will, I guess, crest. But many people seem to think it's coming this summer. I tend to think it will come later. And I'll tell you why. So certainly pre-COVID, consumer filings were down. And in April, which is the last month that I guess it's the last complete month that we have. So it's the last month I have data for, they continued their decline. So last I checked, they were down 30% compared with last April. That being said, Congress, through the CARES Act, did take some steps to make bankruptcy, or try and make bankruptcy, a more attractive option for more consumers. So Section 1113 of the CARES Act basically does some things to protect those stimulus checks that everybody got, what was it, last month or the month before, to protect those from the definition of income for purposes of eligibility for Chapter 7 and 13. And they also, those checks don't count as disposable income that could be applied to things like paying credit card debt if you're in a Chapter 13 case. And then if you are already in a Chapter 13 case, you can request plan modification. So Chapter 13 individual debtors, they create plans to pay off their debt. They can ask to modify their plans based on changes in their income due to COVID-19. These are all temporary provisions. They're not permanent changes to the bankruptcy code. They're set to expire at the end of March next year. And in addition to kind of, I guess, making these changes to the bankruptcy code, Congress also took some steps through the CARES Act to provide relief for consumers outside of bankruptcy. So the CARES Act provides temporary relief for federal student loan borrowers, and also provides protections for homeowners with federally funded mortgages. And so, again, these are all sort of limited protections. For example, with the federally funded mortgages, there's a moratorium basically on foreclosures. That was actually set to expire last week, but both Fannie and Freddie extended their suspensions on mortgage foreclosures. I think now the deadline is June. And so I think, Congress has taken some steps on both the bankruptcy front and the non-bankruptcy front to try and help consumers. at the end of the day, and I put this on the slide, I said bankruptcy is unlikely to be consumers' first choice. And now looking at this, I'm like, when is bankruptcy ever anybody's first choice? But bankruptcy is probably not going to be consumers' first choice, at least not for the moment. Because I think this is for a couple reasons. Primarily what consumers need is money or forbearance, right? So probably what Congress and the CARES Act have done on the stimulus check side and the forbearance side, I think we could potentially be due to see more of that. I also just think it's hard, right, for consumers. If you want to file for bankruptcy, you may not have the money to pay a bankruptcy attorney right now, or you may not even be able to access a bankruptcy attorney due to stay-at-home orders wherever you live. And so that's difficult as well. Some people say, well, if people lose their jobs, then that will affect their ability to access credit. So maybe we'll actually see fewer consumers incurring massive amounts of debt, and then maybe down the line we won't see as many consumer bankruptcies. But the other thing I want to point out with consumer bankruptcies as well is, bankruptcy is a good option for a consumer that is kind of, I guess, functionally at the end of the rope, right? If you are a consumer that expects to be in a position where you are incurring debt for years and years or months and months to come, filing for bankruptcy right now is not going to help you with the debt you incur in the future. And so I think the worry would be that consumers would essentially file too early, and therefore any debt that they incur in the future would be excluded. And the existing evidence that I've seen, the studies on consumer bankruptcy that I've seen, all suggest that consumers really tend to kind of tough it out for a while, that they tend to struggle for 2 to 5 years before they file for bankruptcy. And so my guess, again, educated guess here, is that if we do see a wave of consumer bankruptcy filings, it's not going to be sort of immediately. I actually don't think this summer it's going to happen. Again, I could be proven wrong tomorrow, but my guess is that that's not really what's going to happen. And I do think, again, that Congress has shown some willingness here to help consumers on the bankruptcy and non-bankruptcy fronts. And then finally, I just want to put in it's not a plug, but I wanted to talk a little bit about municipal bankruptcy, because it's the bankruptcy that everybody tends to forget. So municipalities can use Chapter 9 of the Bankruptcy Code to file for bankruptcy relief. So this is like Detroit has done this, right? Or Jefferson County in Alabama has done this. And, municipal bankruptcy filings are quite rare, but we did see a fair number of them during and after the Great Recession. And so I think it's worth a mention here, because we do need to be thinking about whether and how our system can accommodate municipal filings. Fairfield, Alabama, which is outside of Birmingham, actually just filed for Chapter 9 last week. Not really due to COVID, but again, we're starting to see municipalities obviously take a hit on their revenues and on their finances. And the one thing I want to say about this is that many people in government and outside, tend to view municipal financial distress as being caused by financial mismanagement. And I think that's certainly true in many cases, but one thing that's different about the distress caused by COVID-19 is that financial mismanagement probably is playing less of a role here. Now, obviously, a state or a local government, maybe, you could say they could always have done better. They could have had a better rainy day fund or a better funded pension system or something like that. But a lot of the problems that local governments are facing stem from tremendous tax revenue losses, not necessarily from fiscal mismanagement. That's not to say that mismanaged municipalities are going to be scot-free, right? They probably will end up in worse shape than others, but everybody's taking a hit here. And I think that's important to recognize. So I do think we should think about strengthening our existing municipal bankruptcy system to ensure that municipalities can use it if needed. And I do think that this is probably not a popular opinion or an easy opinion, but I think it's probably necessary in the end, because so many municipalities are going to be facing severe distress. And at the end of the day, we might say bankruptcy is what's needed to give them that breathing space, that fresh start that they need to be able to provide necessary services to citizens. Because the number one thing that starts happening when municipalities lose revenue is they start cutting jobs. And the jobs that they're cutting are your paramedics and your fire services and your water people and things like that. And that's pretty basic, a pretty basic necessity. So to that end, I do want to actually wrap up where I started, which is to drive home the point that we will need more personnel in our Chapter 11, or excuse me, in our bankruptcy courts. Thinking just about a Chapter 9 municipal bankruptcy filings, one Chapter 9 case can take up all of a bankruptcy judge's time, or most of it anyway. And so I really think, not just for municipal bankruptcy filings, but if we're going to see a rise in filings generally, the bankruptcy system needs more capacity than it has if we're going to face an onslaught of bankruptcies of any type. So with that, I will stop talking and turn it over to questions.
Thank you so much, Professor Coordes. And we do have a couple questions here, and feel free to add other questions to the chat function as we're moving along. So the first question, have there been any proposals to make more significant changes to the bankruptcy code in light of the economic fallout from COVID-19?
So yeah, more significant changes, yes. Actually, there was a letter that just came out to Congress. I think they sent it around yesterday, recommending some pretty significant changes to the bankruptcy code, specifically actually to subchapter 5 to help small businesses. So to just sort of generally summarize those changes, I think in general, they're recommending, if a small business files for bankruptcy, they're recommending that those small business timelines, so small businesses typically are under a much faster turnaround time to file for bankruptcy or to get their plan out and approved and everything, especially under the new provisions. So the proposal that I saw recommends an automatic 6-month suspension of all small business cases. And then during the suspension, they have recommended changes to the bankruptcy code to allow small businesses to basically continue operating, but they'd be under the protection of the automatic stay. They would have protections for secured creditors, and they would have different sort of tweaks to the bankruptcy code to enable sort of just like a halt to allow these small businesses to kind of catch their breath. And so I think that's a really interesting proposal, and it's one that just came across my desk yesterday. I have seen other proposals come in. There's been proposals about like a super Chapter 11, where we kind of gather a bunch of similar businesses and attempt to kind of restructure debt on a larger level. So there's a lot of really interesting stuff going on right now. I do think one of the challenges, and this is why I tend to focus on like sort of the procedural aspect, like let's just bulk up our capacity. One of the challenges is getting Congress to pay attention to these proposals, to act on these proposals. And ultimately, there's a big timing question, because if we do see a rise in filings, then I think, any changes that are proposed, they have to be put into legislation and then passed and then take effect, and that process could take a long time. So I do think this is a great time to be thinking about major changes to the bankruptcy code or our bankruptcy system, just because we're going to probably be tested on that, on the strength of our system. But I also think that right now, it can be difficult to enact those changes quickly enough, potentially, for them to be really useful in the near term.
Is interest currently accruing on student loans?
Is this a question from personal experience? I totally get it. So the CARES Act does provide, so for federal student loan borrowers, the CARES Act provides that the Secretary of Education will defer student loan payments, principal, and interest for 6 months. So that would be through, this was 6 months from March, so through September 30th, without penalty to the borrower. So most borrowers have, I think it's like 95% of student loan borrowers have federal student loans. So in most cases, right, there is a suspension of principal and interest and payments. But again, that only applies to federal student loan borrowers. If you've consolidated your student loans, and this is not legal advice, by the way, obviously check, right? Check with your lender, and check with a lawyer if you're not sure. But I think in general, the federal student loan borrowers, which is a good portion of student loan borrowers, are seeing some relief.
Can you talk about the Fed's municipal liquidity facility? Is that likely to help struggling municipalities?
Sure. So the municipal liquidity facility. So this is one of, I think it's 8 or 9 emergency sort of funding measures that the Federal Reserve, has put into place. Basically, at the end of March, the municipal securities market took a real hit, and the Fed was like, "Shoot, we need to do something." And so they created this municipal liquidity, municipal lending facility to address, really, I guess, more to be sort of a backstop for municipalities, to sort of stabilize the market if the market needed to be stabilized. Initially, it was pretty narrow in scope. It only applied to all 50 states, but it only applied to about 27 cities or counties. There was a population cutoff. They have expanded the scope of the facility. Now I think over 200 cities and counties can use it. They lowered the population threshold. It's a 3-year facility. Basically, it allows municipalities to borrow certain funds. The amount you can borrow is tied to your revenue. You can borrow, I think it's 20% of your revenues. And the rates are not great. Obviously, rates depend on ratings, but the rates are pretty steep. And so the reactions that I've seen is to the municipal liquidity facility is that it's a good thing to have as a backstop. But actually, the municipal securities market seems to be stabilizing. Illinois earlier this month was able to sell $800 million worth of bonds. And Illinois is like, not doing super well, considering among the states. And so the fact that Illinois was sort of able to do this suggests that the market is maybe stabilizing. I think that the Metropolitan Transit Authority in New York City also was able to sell some debt. So I think that there are some indications here that the market's improving. But the municipal liquidity facility is there as a backstop, right? It provides cities, states, counties the ability to borrow money from the feds, so that they can continue providing essential services if they need to. It is, again, kind of a backstop. The Fed really wants to be the municipalities and states' lender of last resort. It does not want to be sort of their first choice. And so I don't think I have seen any takers for the municipal liquidity facility as of yet. But I do think my sense is that state and local governments are happy that it's there. Because maybe it's not going to be needed now, but maybe it will be needed in a few months. And at any rate, it does seem to be working as a backstop because the market for municipal securities and municipal debt is doing okay.
Can you discuss a bit about how the subchapter 5 within chapter 11 could work to benefit a smaller commercial property landlord to restructure an existing loan on a commercial property? So a small business is the classification.
Okay, yeah, I mean, so there's a lot to subchapter 5. So I can't, but basically, it does provide, I think, a number of different benefits that that could help in the long run. So I mean, it does provide for sort of faster, for you to be able to move through bankruptcy faster. Again, there's been some proposals to kind of change that timeline. But in general, it's designed kind of to be a mashup of Chapter 11 and Chapter 13 of the Bankruptcy Code. And so it has these features that it's drawing from both. So there's I think there's different features that may really help small businesses in the near future. Let's see. So again, Congress has recently raised the debt limit, so that's good. More businesses are eligible, although not all. Just like in a Chapter 13 case, the debtor enters into a plan that spreads its debt over 3 to 5 years. So during that 3 to 5 year period, the debtor does have to provide all of its projected disposable income to its creditors. But again, it's spread over a 3 to 5 year time period. In addition, any administrative expenses that are incurred during the case, so expenses that are incurred as part of the bankruptcy case, can also be paid out over that 3 to 5 year period. So that's, I think, something that is good. And then again, you have the quick movement, right? So that conserves costs as well. And then the one thing that I would also flag as well is, a lot of small business owners are at bottom just individuals, right? And so they have their personal life is sort of inextricably tied up with the business. And so if the debtor or the principal of the debtor, the owner of the debtor, is using their primary residence as security for a loan to fund the small business, then this is actually something really neat and new. The plan can modify the loan. And so that's, I think, a huge deal as well. So again, I don't want to speak to too many individual situations, but I do think that it's worth taking a look at some of those features that are sort of a hybrid of Chapter 13 features, where you can spread your debt over a period of 3 to 5 years. You don't get the discharge until the end of the plan period, but that helps. It does help as well, again, if they're using their principal residence as security for a loan, it helps with that. And it's a good opportunity as well, of course, to get that breathing space and to negotiate with creditors, with tenants or landlords, right? And so I think that that's a good, maybe a good use right now. I will caution, again, I kind of mentioned this in the talk, that those Paycheck Protection Program funds, I believe that the current guidance from the Small Business Administration is that if you're in bankruptcy, you can't access those funds. So that's just something to think about as well. I'm not sure, but that's a consideration for many small businesses. Some bankruptcy courts have said, no, you should be allowed to access them. We think you should be able to access them. But that's an issue that I think is still kind of in dispute as to whether, if you're in bankruptcy, you can get those funds.
That looks like all the questions we have. So Professor Coordes, thank you so much for sharing your expertise with us today. Thank you to everyone for joining us. We will send out, like I said earlier, this recording of this presentation as well as the PowerPoint. And we are looking forward to connecting with you guys again in the future. Thanks so much for joining us.
Thank you.